We have, sorry, we just had to switch rooms here, so I'm a little out of breath. But let's get started. We have two presentations today. And hold on 1 second. I just need to get my notes up here. Hold on. No. I can't get back to my 1 second. So, all right, so here we are. And 1 sec, sorry. So yeah, so we have Tobias Schroeder. He's a director of the e-rule making program at United States General Services Administration. And then we have Ransom Widener, who's the VP of Pro Bono and Social Impact at Wilson Sonsini's 650 Technologies company. And so, it'll be a very interesting discussion today. And yeah, before we launch into the presentations, does anyone have any updates for the group or any news to share? Please go ahead and do so. Otherwise, we will turn it over to Tobias. All right, Tobias, turn it over to you. Can see you there already. Hey, Harry. Good. Tobias, are you there? We can't. I think you're on mute. Maybe it's
me okay now. Can you hear me?
Yes, Tobias. Now we can hear you. Great.
Okay. Fantastic. Okay. Thank you for the proper German pronunciation of my name.
Yeah.
My grandparents would have been very pleased with that. Can you see my slides as well?
Say again?
Can you see my slides as well?
We can see your slides, yeah.
Okay, fantastic. So thank you, Dr. Vogel, for the opportunity to speak today. I'll start off with a couple of quick disclaimers. Although we seek to promote cross-governmental efficiency and interoperability with other parts of the federal government involved in regulatory process, GSA does not speak for OMB's Office of Information Regulatory Affairs, individual rulemaking agencies, or other federal shared IT regulatory service providers, including the Office of Federal Register and the Government Publishing Office. I'll also be discussing a modernization effort that's in its early stages. This is a journey that starts with a target solution architecture and roadmap, but a variety of other factors and lessons learned along the way can impact what is ultimately delivered and when. So now that I've gotten that out of the way, I'll look forward to diving into this set of topics with you. This audience presents a fun dynamic for me. The majority of my professional career, I've been surrounded by IT generalists who are confident and comfortable with what they know. And when presented with concepts of legal knowledge representation and legal knowledge-based intelligent systems, I often get blank stares, worried or dismissive looks, and a healthy dose of skepticism. By contrast, my audience today includes experts like Dr. Megan Ma, who likely know more about this field of research than I ever will. So I welcome your questions and comments at the end of the presentation, and I look forward to learning something myself. So here's the agenda. I'll start off with the existential question that you at CodeX ponder on: what the heck is legal tech anyway? Then I hope to take you full circle. I'll describe a function-based perspective of legal tech that's more focused on what work the technology is supporting rather than how it works under the hood. Many private and public sector IT solutions, including GSA's existing regulatory IT systems, apply general technology approaches to legal business needs and rebrand them as legal tech. I'll then transition to a different perspective of legal tech. Central to all of this legal work is the law or regulation itself. We're all knowledge workers, and legal knowledge drives and informs our work. When standard and open approaches for legal knowledge representation are part of the solution under the hood, we're all better equipped to deal with unique challenges and deliver better business needs. So next I'll describe reimagine. I'm sorry? Okay. Next I'll describe a reimagined approach. in which legal knowledge can be combined with legal knowledge-based expert systems to more efficiently manage legal work. This has been described as separating the know from the flow. In my view, specialized information technology that helps legal knowledge workers to interact with legal knowledge is what makes legal tech legal tech. So to bring it full circle, I'll revisit the functional market categories, and I hope to see light bulbs popping up over the audience members' heads with the realization of how important it is to know what's underneath the hood for all legal services and whether they can leverage and benefit from open standards for legal information. The role of government as the steward of legal information would be central to realizing this vision. So what is legal tech? In a meta sense, legal tech and reg tech are buzzwords that convey nothing more than a vague connection between technology and legal work. FinTech gets thrown in there because the financial sector is heavily regulated across multiple jurisdictions and it has the resources to invest in technology solutions. The last time that I checked, Gartner has no magic quadrants or market guides for any of these buzzwords, but there are sub-market categories like enterprise legal management solutions for legal operations or legal matter management for information workflows. The Gartner hype cycle for legal and compliance technologies covers a broad range of other sub-market categories that are tangentially related, such as risk management solutions and smart contracts. Nonetheless, the general buzzwords invoke a mystique of a potential growth market. Forrester Research predicted that RegTech funding would explode in 2020. And I love the title of one of their blogs that says, New Tech Spotlight, a growing crop of RegTech startups vie for unicorn status. So the picture on the slide is my own take on the three blind men and an elephant. When topics of legal tech and RegTech are framed too loosely, people can have lots of circular conversations. Someone takes a position, maybe they generalize whether AI should or should not have a role in legal analysis. That position can't be clearly supported without specific context, like what kind of AI for what type of legal research. The person on the other end of the conversation has framed the issue a little differently in their head, and they go down a different rabbit hole. So students and research fellows at Stanford who have had to stand behind a thesis or a dissertation would likely agree that this kind of loose framing would not be conducive to research and development. In my case, the same is true for market research into potential solutions for modernizing GSA's regulatory IT systems. So, this is an older presentation. So that's why I value discipline analysis into the intersection of information technology and law. The Stanford Center for Legal Informatics is one among several international academic and research institutions that dissect and analyze the broad field of legal tech. So borrowed directly from your own website, here's CodeX's conceptually organized listing that analyzes this broad universe of legal tech. I'm personally interested in these projects and the intersections across the categories of legal document management, legal infrastructure, and computational law, and I'll circle back to this later. I apologize, I have an older presentation here that I pulled up, but and I'm sort of getting my bearings here a little bit. But I'm the director of a program seeking to modernize GSA's regulatory IT systems. So people in my position might be tempted to skip the dense research and just look for a list of off-the-shelf products. So I'll start where most people would, which is the CodeX Tech Index. And for some reason, it's a little bit off right now, but I'll still be able to catch up and speak to this. So when you click on the CodeX Tech Index, if you'll bear with me, I'm going to stop sharing for just a second so I can get the right slide deck up. I apologize. Can you still hear me okay on the phone?
We can, yeah, we can hear you fine.
Yeah, I apologize. I'm having a little difficulty. I'm going to rejoin the Zoom session as well. It'll just take me a moment. Thank you for bearing with me.
Yeah, no worries. Well, we'll catch up separately in the meantime. All right, any other updates from folks in the group? How about you guys?
Well,
We have Professor Certain
yes,
visiting here.
back in town, plan on, being here every couple weeks again now that the semester's started
Yeah.
up. Really good to be home and see everybody here.
Great to have you here.
Do some
and-
beautiful contracts, fun. You were already doing it. Pierre and Will and I were just meeting earlier, working on
It's
stuff.
great.
Yeah.
It's great. Yeah, we should actually report out to this group sometime in the near future, which we haven't done in a little while. So I think that would be a really good conversation. We have Andrew here, who's a visiting researcher from Toronto, and Tobias is connecting again. Yeah, today is a day of like technical challenges, and so
At least Stanford has power these days.
we have power. Yeah, there you go.
We're having some power issues.
Yeah,
The hamster is not running around the wheel fast enough.
exactly.
Wouldn't get a hamster, Probably an undergrad. Right, exactly.
The campus is dangerous again with all this bike
All the
traffic.
bikes,
You
I
know, it's
know.
like
Okay, thank you, everybody. I'll go ahead and get this restarted. Can you all hear me okay now?
yeah.
Okay, fantastic. I'll try to get through this as quickly as possible so I can catch up. Okay, so where I last left off is just that I'm a director of a federal shared IT service, and I'm doing market research. So I value the types of research and information that's conceived, researched, conceptually organized by the different research institutions like CodeX. So looking into your own website and the CodeX Tech Index is an example of how the market's generally broken down into broad sets of categories. So you can even drill in a bit here. You get a list of vendors and a set of tags and target audiences that apply to the vendors displayed. I blanked out the list of companies as a matter of our internal policies for not displaying vendor names in our communications materials. So it only makes sense to break down the market based off of functional categories. The companies wouldn't invest money into building a solution unless there was value to be provided for the market need. In this case, law firms might want to know what's out there to help make a more efficient use of their law librarian's time. There are other resources that take similar function-based approach for the legal marketscape. I won't be displaying their market landscapes for the same reason of not displaying vendor names. But one source provides a legal AI landscape. A variety of vendors are listed for functional categories, including e-discovery, expertise, automation, intellectual property. A separate market landscape focuses on legal operations, and that landscape tends to list those functional categories from the least to most mature, with office software suites on the low end of the spectrum and something that they call legal knowledge automation listed on the high end. There's even a new startup that I spotted through LinkedIn, and their whole business model appears to be focused on helping people to do market research for legal tech. So the federal government's not unlike a law firm seeking to make aspects of its operations more efficient through improved research and workflow automation. The function of government that the e-rulemaking program has historically supported is driven by the Administrative Procedure Act of 1946. In the era of the New Deal, there was a proliferation of agency regulatory activity. There was a concern that regulations had a force of law, but the agencies who were writing them didn't have the same checks and balances that existed for the legislative branch when enacting statutes. In part, the Administrative Procedure Act imposed checks on this authority through public notice and comment. So administering this function, it's work. And the E-Government Act of 2002 explicitly required that this function be automated through electronic means. In the same year that the E-Government Act required electronic notice and comment, the E-Government Strategy of 2002
sought to consolidate redundant government functions into shared IT services. The e-rulemaking program was born in 2002, and it rolled out the first shared IT services around 2006. This graphic depicts what we've been doing ever since. As required by the Administrative Procedure Act, a notice of proposed rulemaking is published in the Federal Register, which is now available as an electronic document through the federalregister.gov or govinfo.gov. In parallel, the e-rulemaking partner agencies create an electronic docket in the Federal Docket Management System, or FDMS, our agency-facing application. The agency electronically links the electronic document with register.gov, and they can also populate the docket with electronic documents related to the proposed rulemaking, such as regulatory impact analyses. The agency then publishes the documents through regulations.gov, our public-facing website. The public can then view the documents, comment on them. In turn, the comments are viewed by the agency through FDMS. They can publish the comments back out to regulations.gov so other commenters can see what other people are submitting. So in a nutshell, we do electronic regulatory notice and comment. The problem is that the technology stack hasn't changed much since it was first put into place in 2006. In the meantime, the systems have accumulated a significant amount of technology debt. The application is so tightly coupled with a document management system, and the version of software is so old that a full-scale modernization is needed. As the program looks toward modernization, other new risks, challenges, and opportunities need to be accounted for. So the needs of e-rulemaking are unique enough that sector-specific market research is warranted. So it's 2002 and we have this whole RegTech thing and all of these marketscapes that I talked about in the first set of slides. The problem is that the market categories that I've showed are largely oriented toward the private sector. The Tech Index deserves credit for the target audience feature, which includes government. This is helpful, but there's really not a market category that's well suited for the overall electronic regulatory notice and comment process. In practice, the market for this specific function is limited to the e-rulemaking shared service as it currently exists and one-off websites managed by agencies like that. Given this reality, the tendency might be to think about how general functions associated with legal work have IT solutions. So specifically, why not just get an updated document management platform, something that's similar to the technology that we used in 2006, but I'm not satisfied with that. So more market research is really warranted, but what next? So it's not just the uniqueness of the business need that's at issue, it's the role of government. So I'm now borrowing language from the CodeX YouTube channel. I highlight here an aspiration that's shared by the e-rulemaking program. In addition to implementing legal processes, the government's also the source of policies, and it acts as the steward of legal information. So how the government serves these roles impacts the extent to which technology can support the ability of all regulatory stakeholders as they consider, search, analyze, comment, and comply with regulations. This information-centric perspective helps us to see the work of e-rulemaking in a new light. Historically, the e-rulemaking program is a success story. Through the magic of the internet, it created a one-stop experience for the public to access and comment on the rulemakings from multiple agencies. For the agencies, it provided the ability to electronically receive and review comments and do so efficiently through essentially outsourced service. There's a problem, however, with the existing services. We only push PDFs around through a process. The potential value of information technology for dealing with the content that's locked inside those electronic documents is not being fully realized. From the perspective of public commenters and small businesses, who really has the time to read the Federal Register every day? If they skip the Federal Register and go straight to the regulations.gov, how will they find proposed rulemakings that are relevant to their context or interest? Even if the current user experience for search was a lot better, the public stakeholder will often have to read the document to fully understand the potential relevance. The potential intersections with other policies would require independent searches and lots of manual analysis of a lot of text. Agencies might not fully appreciate the experience of the public. So I call this domain-centric thinking. When focusing on the regulatory domain, agency staff can tend to take government-centric frame of reference. As we modernize our systems, we want to leave open the possibility of supporting other aspects of the larger rulemaking process. The example here is EPA's action development process, but other agencies have similar approaches. When developing a rule, agencies are of course worried about how they craft the rule in human language. To consider how it's going to be implemented and to analyze the potential impacts and benefits, however, agencies will also go through some form of abstraction that represents concepts and workflows in more structured ways. It helps the left side of the brain figure things out. The picture in the upper right hand of this slide shows an exercise with Post-it notes. The product at the end of this process goes back to being text. Someone will often think, hey, this was useful. Let's take a picture of the Post-it notes and the flowcharts. But abstractions used to analyze and develop the rule are soon forgotten. To the agency, it seems like a finite amount of text to process. Once the regulation's codified, the regulated entities and the public would simply find it and read it. From the perspective of the citizen or the regulated entity, however, there could be multiple jurisdictions and even offices within those jurisdictions that could be relevant. This is depicted on the left. If the private sector entity wants to engage in the process while the rule is being considered, the challenges are depicted on the right. Information about the same regulatory action resides in multiple silos. Even when it's electronically available on the web, wading through an ever-increasing mountain of text-based information can still be a human resource-intensive process. A complex web of interdependencies across regulations makes it even more of a challenge. Any one of the interdependent regulations can change over time. So imagine being a national or international bank regulated by multiple jurisdictions. So a reimagined approach. This is where I get to thinking about how legal tech and market research can be applied toward my modernization. So there are limits to traditional government contract RFIs and finding existing technology solutions for the needs of e-rulemaking. As I described in previous slides, finding IT products directly relevant to my needs is difficult when reviewing specialized market landscapes for legal tech. In the United States, the existing e-rulemaking system and one-off agency websites represent the extent of the existing market of government off-the-shelf solutions. So the logical thing to do would be to investigate what other countries are doing in this space. It turns out that the challenges of legal work and information management are not unique to the United States. It also turns out that there are mature solutions in place that have been applied using open standards in overall research and development of academic institutions like CodeX. It's not just that the solutions can address both the know and the flow of legal knowledge work as an interesting approach. It's that the separate but orchestrated use of the know and the flow lead to practical value in both improved customer outcomes and cost-effective management of IT applications. In other words, this is not what Forrester Research would call a unicorn. It's about rebranding. It's not about rebranding general IT solutions as RegTech and then hyping up the value. It's about research and development, trial and error to find the technology approach that best addresses the unique challenges of legal knowledge work. The vendor that was selected for our proof of concept and subsequent modernization contract, which was just awarded literally a couple of days ago, has supported complex agency-wide and government-wide policy workflows for 17 national tax administrations, 5 social security agencies, 3 immigration services, and a lot of other public and private sector organizations across all domains of government financial services. When evaluating vendors, we looked for the ability to conform to established standards and to be employed in a modular architecture. This was intended to not only support interoperability, but to avoid vendor lock-in. As the technology space continues to expand, I look forward to growing competition among vendors who can similarly conform to open standards. Because the architecture is decentralized and modular, I'd be able to swap vendors in now. So this graphic depicts the collective technology approach under consideration for the e-rulemaking modernization. The bottom 2 rows show the know. The top 2 rows show the flow. The foundation starts at the bottom and each successive tier moving up builds on the previous tiers. On their own, the standards represented at the bottom of the slide can provide tremendous value for legal publication and research within and across borders. The more advanced structures on the second tier can be represented in knowledge graphs and ontologies that can help to capture domain-specific concepts, relationships, and declarative business rules. This requires explicit interpretations of policies by humans, preferably the original people who are writing the rules. It's hard, but these standard models and approaches are the most practical and efficient way that I've seen for accomplishing it. If it's done well and it's done early in the rulemaking process, it can support upfront analysis, and the structures are available downstream for other applications. When combined with the specialized software platforms at the top 2 tiers, these metadata can help to deliver intelligent services able to deal with complexities and intersections of policies. The applications in these top tiers can reference the normative sources on the bottom tier. The applications can also leverage the knowledge graphs in the second tier to support analysis and inferencing. So as it relates to market research and viability for our modernization, I wanted to make sure the bottom two layers were based off of open standards. For the bottom tier, the US legislative markup language is under adoption at the Office of Federal Register, Government Publishing Office, and Congress. For the second tier, Flint is undergoing review for IAAA certification. For the top two tiers, past performance in making this entire concept work was the most important for me.
And
So,
just a quick reminder on the time, you sort of, we're running a little bit out of time, and we'd love to be able to ask some questions too, but.
Well, I think that's actually a good stopping point. I'll stop sharing my presentation. I got to the point of talking about the IT solution architecture. I apologize for going so long and for the difficulties with the wrong presentation.
No, this
I'm
is
open to
great.
questions.
Thank you so much. Yeah, super interesting and super exciting. I think so I'm, one of the questions I had is, what's e-rule making? What does that mean? Is this mostly about, publishing the regulations in some kind of computable format, or is it about the entire process of engaging with the public also, and in workflows that, that make it transparent for them what's going on, that make contextualize regulations that are relevant for them, or is it both? And I think you talked a little bit about it at the end, that there are standards you're using for these markup languages. I think that's one thing. We had a project that our research director, Mike Geneseret, started here some years ago that we called Corporate Ledges, where we actually wanted to model like laws, like statutes in a fully computable form, which obviously is an enormous undertaking. And we wanted it to be sort of a community effort where people would, when they work on a project, right? We had different distinct projects, and we were modeling certain sections of the tax code or whatever, or the Veterans Administration benefits code. And then we would put a computable version out there, and we'd hope that the community could then do the same, right? Because at the moment, there's all this different efforts going on where people model parts of the law, but it's never shared as a commons. And I wonder if that's sort of like on your horizon to like go sort of beyond just the markup languages to facilitate queries. So if you actually wanted to go deeper into, fully making certain sections of regulations fully two Anyway, so that there's a lot of different questions in there.
Yeah, big question, but I think I get the gist. There's levels of abstraction. At the highest level, we facilitate a process from when a statute, says that an agency should write regulations. Maybe there's the Clean Air Act, EPA writes some regulations about that, within the scope of the Clean Air Act. So there's this process that goes along with that, and we have a piece of that process. And that's the notice and comment piece, where the agencies present materials and seek public comment. That aspect of it itself is a regulated process. There's executive orders from the Office of Management and Budget, the Office of Information Regulatory Affairs, with all the supporting guidance that tell you how agencies ought to do this. That it provides sort of guardrails around, if this is a significant, economically significant role, then you have to go through these kinds of oversight things. There's Unfunded Mandates Reform Act. There's all kinds of things that you would have to know as an agency when you're putting something through a process. So on the one hand, what I'm looking for is a technology that can do case management, help you navigate that process in the most efficient way. So based off of the nature of the rulemaking that you're doing, what's the most efficient process for you to do it? The other level of abstraction is that the product of the rulemaking process itself is a regulation. And that's where we can get into, I think, where your question is of, can you make computable versions of that? And I think that you can, and there's a lot of past performance in that, where it's been done successfully in other countries. So what the Office of Federal Register, the Government Publishing Office and Congress are doing is XML-based structures. And that's not really rules as code, but what it's doing is it's, instead of working with like a Word document to show you a regulation, it breaks it down to its component pieces and marks it up. It's really helpful. But when you get down to a point of granularity, you still have to read some text to understand when does this rule, who does this rule apply to? When it does apply to you, who has to do what? And that's where legal knowledge graphs come in. And that's where the Flint standard comes in. And it's not so much about rules as code or to fully represent it or make it computable. It's more about providing context. And that context helps you to do predictive analysis. How many people will this affect? How much more will the better safety for workers be? How cleaner will the environment be? And those kinds of analyses can benefit from those structures. Those structures can also be leveraged as inferencing tools. So for me, it's about being able to provide context about a rule that helps you to discover it, know whether it's relevant to you, know how it intersects with other regulations and so on. And you have to do it in a prioritized way because you can't do it for all regulations. So those regulations that are the most impactful to society and that have the most burdensome processes is where I would do that. So I also see a question from the chat, and it says, you realize you can't speak on behalf of other agencies, but where might regulations.gov relate to the ECFR and the Federal Register? So we're early in the process. The Federal Register is part of that early part of the rulemaking process where you publish a notice of proposed rulemaking. Okay, and then we link to that Federal Register with our dockets, and then we seek the comments. When it's finally codified, that's where it's residing in the ECFR. So there are silos of information about the same regulatory action in these different agencies. And part of my goal with modernization is to make sure that we can also structure our information in the same way that they're structuring theirs, and they can all be cross-referenced. That way, somebody that's doing legal research doesn't have to go across all the platforms. They can more seamlessly link to, pull from, or navigate across these different entities. So there's a data, so I don't want to take away from
this is good. Yeah, it is super interesting, and I think this is the topic itself would sort of lend itself for an entire full day conference, and I think this was a great way to kind of sort of start a conversation with our group, and I hope there'll be opportunities to continue the conversation. And if folks today have any more specific questions for Tobias, maybe Tobias, if you could share your email address in the chat so that people could reach out to you directly, I think that would be great.
Yeah, just one last ask with my last 30 seconds.
Oh, sure, go ahead.
I'm hiring, right? So I have a contractor that's capable of doing this cool technology approach. And I'm also staffing up, and one of my positions is for a content strategist, and my desire is to find somebody that has gotten their toes wet with this idea of computational law, as you guys describe it. I call it legal knowledge representation. So if anyone's listening on here, you are aware of any of your students or your colleagues that might be interested in helping to modernize regulatory process in government, email me, and I will put my email in.
That's great. And thanks for that. I'm sure, in this group, I'm sure folks will know some great candidates for this opportunity. And I would encourage you to also perhaps share it on the CodeX LinkedIn group. This is really, I think, sounds like a fantastic opportunity, and Harry should share it with your students too.
Absolutely.
So, but yeah, thank you, Tobias. This is really great, and thanks for giving us sort of a glimpse at your work there at the GSA, and it's very exciting. It's very encouraging that the government's working on these ambitious projects. I think that will create a lot of opportunity for more transparency, new applications, like you say, and so really, really great that you're doing this work, and thanks you again for sharing. So a quick round of applause for Tobias. Thanks again, and we'll turn it over to Ransom now, if you're there.
Yes, thank you so much. I really appreciate it, Roland. Thank you very much, Tobias, as well. It's fantastic. I really enjoyed that. I'll just get my screen sharing going real quick so everybody can see what's going on. And now, if everything went according to plan, you should all be seeing my screen. Thank you again. My name is Ransom Widener. I am Vice President of Pro Bono and social impact at 650 Technologies LLC. 650 is the technology subsidiary of the law firm Wilson Sonsini. And I'm really excited to talk about our mission to make the law more accessible. I'm going to start with two quick stories from my life about the law and about accessibility. So I was born at home, this house here, in the middle of nowhere, Cane Beds, Arizona. Actually, I was born at the neighbor's home because this was our home and it had no water or electricity, and it's not a good place to have a baby. My dad had moved us to Cane Beds, Arizona. My dad was a very interesting character, brilliant, spoke 10 languages fluently, but a little bit quirky and a lot of it anti-government. And so that's why we lived, in the middle of nowhere in the first place. It's why my parents made a lot of kind of strange decisions. One of those strange decisions was they decided not to report my birth to the government. So I had no birth certificate and no social security number. What they did instead was they wrote down my, weight and length and time of birth in our family Bible. And that was, my birth certificate until I was 17 years old. And I was homeschooled. We didn't go to the doctor. We were very off the grid. Then when I was 15, I decided I wanted to drive. I told my parents I wanted a driver's license. And that meant a lot of things. It meant getting, a birth certificate, not one that's written on a page in the Bible, and getting a social security number, which my dad called the mark of the beast. So it was a bit of a fight, but my mom took my side and my mom decided to help me out. My mom had no knowledge of the law, no resources at all. I mean, we weren't poor. We were like fringes of society poor, but with no resources at all. My mom, with her persistence and just never giving up, she's a spectacular person. 2 years later, 2 very hard, difficult years later, I had a birth certificate. 17 years old, I finally had a certificate of delayed birth, or a delayed certificate of birth is what it says here, and a social security number. Then she did the same thing for my little brothers who were, similarly strange childhoods and birth situations. Fast forward 10 years, and I was a musician, pursuing a dream of a professional music career. And my band had won this contest. And if we won one more round of the contest, we would get to play this big music festival in Spain. And it was a huge opportunity for us. But I was terrified because I didn't have a passport. And I knew it was going to be really hard to get a passport. My little brother had been trying for over a year at this point to get his passport, so far unsuccessfully. And it had been so hard to get my social security number. And I only had 4 months. We'd find out if we won and would be going to Spain in 4 months. So I started hustling. And the way that most people interact with the law is through forms, most individuals. And I filled out a lot of forms. I spent months, tracking down every scrap of government record I could find, filling out a ton of forms. But the forms kept asking for things that I didn't have. The government needed a hospital record. They needed a census record. And I had never had either of those. I called people, I tried to explain, I wrote letters, and I got absolutely nowhere. Then a week before the deadline, the State Department sent me a letter. And the letter said, "You are out of options. You tried it all. And without the records that we need, we can't issue you a passport. We can't issue you a passport ever." And that, that was a little bit unexpected. That hit me hard because I'd gone into it thinking, well, this will be really difficult. Maybe I won't get my passport. Maybe I'll blow this opportunity, but eventually I'd be able to, and I'd always dreamed of one day seeing the world. I was this poor kid living in the middle of nowhere. And now I had this letter that said, no, you're never leaving the country. Not for this contest. Not on your honeymoon someday, never. And it was really depressing. And I told some friends about it, just sort of confiding to them. And my friend Rob said that I should talk to my member of Congress, my representative. Rob had worked for a congressman a few years before this. And he said, this is something they do. They help constituents with passports. And I was almost mad to hear that because in all of my pleading phone calls and letters, is there anything else I can do? Is there anybody else I can talk to? Nobody at the State Department ever said, yeah, maybe, talk to your congressional representative. And I did a lot of looking. I spent 4 months turning over what I thought was every rock, but I'd never seen this particular thing, as an option. I only found out because I happened to know somebody who happened to know this, valuable to me information. So I filled out this form. I don't know any congressman. I just went to the website, filled out a form, and the next day, two staff members from Chris Stewart's office got in touch with me. They emailed me another form. And this form they emailed me, it gave them permission to access my records, and I'm thinking, good luck. I access my records, they're garbage, not gonna work. But sure enough, 2 days later, they called me back and they said, great news, your passport application has been approved. 3 days later, I had it in my hands. I had taken the picture earlier. My hair is so tall in this picture that it's cut off. And it's like I got like a Dolph Lundgren haircut, but I loved it. I was so excited. And it took them 5 days. I've been doing this for months, stressing out for months. I remembered my mom had spent 2 years getting my social security number. And, these congressional staffers probably wasn't the only thing they were doing in those 5 days either. 5 days later, I had my passport. If you're wondering, by the way, my band did not win that contest, didn't go to Spain, broke up that year actually. But the point of these stories is that difference, right? So it took my mom years to get my birth certificate. It took me months to try and fail to get my passport. But then someone with knowledge and power and access did the same thing, and it worked for them. It worked in 5 days. Nothing changed in those 5 days. My life, my records, my weird childhood, that was all the same. The difference was knowledge and power and access. And I'm really glad it worked. We didn't go to Spain when we won that contest. I have been able to travel and see the world a little bit, though. I'm very glad I've got this fantastic passport with this, picture of how tall my hair used to be. But that's not how it's supposed to work. Normal people should have the same access to the law as powerful people. This wasn't, obviously a member of Congress has different access to some things, but I just signed a piece of paper that gave these members of my congressman's staff the same access that I had to my own records. But that access didn't work for me and it did work for them. And that's the point. That's the problem I want to talk about, because the law is for everyone. The law belongs to us. It's like public parks and libraries, how they belong to us. It's ours. We should feel empowered by the law, not intimidated by it. But the reality is that normal people, and powerful people don't have the same access to the law. I don't have to tell anybody here about, the access to justice gap. 50 million Americans at least have unmet legal needs. And we try to fill that gap a lot of ways. Attorneys volunteer their time, courts set up self-help resources, Stanford creates CodeX, and all these wonderful, people who participate in CodeX. 650's strategy for closing the access to justice gap is something that we call pro bono at scale. And, we didn't come up with this idea, but this is how we do it. Super quick, because it kind of helps set the tone. 650 has two sides of our business. We have a side that makes money. We automate complex legal documents for companies like employment agreements and employee handbooks, stuff that accounts for the law in every state. So we make world-class legal documents more affordable and accessible to companies. We do a similar thing on the other side. The other side of the business is free tools for people who can't afford legal help, people like me and my mom when I was growing up. And that's a lot of people, at least 50 million people who need a lot of help with very complicated problems, because the law is very complicated. But complicated things can be accessible. Technology is really good at making complicated things accessible. And 650 focuses on doing this 3 ways. So we look at upstream solutions, helping the helpers, and simple forms. I'm going to take just a couple minutes. We're going to look at each one of these, how 650 approaches it. We'll do a quick demo of one of these help the helper tools. And then we should still have about 5-10 minutes at the end for discussion. Any questions so far? Everybody feeling good? And I make sure everybody's been able to see my screen this whole time. I hope. Thanks. So I want to start with upstream solutions. Upstream solutions, here's a great quote that sort of illustrates why we call it upstream solutions. Upstream solutions are ways that 650 tries to help people avoid court, kind of, nip things in the bud, solve a problem early. And that's because court is a hard place for people who can't afford an attorney. No, of course, sometimes court is the best option for somebody. And sometimes, often, court is the only option for somebody. But whenever possible, 650 tries to help people avoid court. And we built a few tools for this. The first was something called Hello Landlord. We built that with LawX at BYU and Innovation for Justice at the University of Arizona. It helps renters write the kind of letter that a lawyer would write, letters about eviction and repairs, for example. We're also, by the way, these letters have been used tens of thousands of times, which is fantastic. They've had a tremendous impact. These are just a couple of emails we've received from people who have used Hello Landlord, and they've given us permission to use these, by the way. We're building a new tool for debt collection in a similar way. We'll use best practices from the Consumer Financial Protection Bureau. So we're taking all of that knowledge, like 650, Wilson Sonsini, Consumer Financial Protection Bureau, taking all that knowledge, then using technology to deliver it to people who need it so that they can avoid court, where the playing field is very often uneven. In Utah, the playing field is frequently uneven between people who are being sued for a debt or being evicted and the people suing them. Now I want to talk about helping the helpers, and here's where we'll do a little bit of a demo. People are always warning me not to do live demos, but it's the only thing. This will be kind of live, kind of on the rails, mostly because my internet connection isn't super fast at home. We built a tool called Identity 650, a free tool called Identity 650, because sometimes you can't avoid court. Some things have to be done in court. In Utah, name and gender marker changes always require a hearing, always require a petition. So we built this free tool. It automates the paperwork for a name or a gender marker change in Utah. I'm going to choose gender marker change here. Takes me to a place where I can create a free account. 650 does not use this information or any information we gather for our pro bono tools for marketing. We don't sell it. We don't trade it. We only use our pro bono, anything gathered by our pro bono tools to create the documents people need, to deliver them to you, and then to keep you updated if a law changes or a rule changes or something changes in a way that affects your documents. So I'll do in the interest of time, I'll do the old baking show move where I just say, here's one I put in the oven earlier. So here's our gender marker change tool. We provide information about the law. We have some resources you can click on. Throughout the tool, we're providing information, not advice. We can help people check eligibility and generate all of the documents that they need, but only the documents tailored for their situation. So for example, in Utah, you need evidence of appropriate clinical care for gender transition. And we talked to a number of attorneys. We talked to people who are, specialist judges, and they said, here's all the things you need for a letter from a doctor. And so we created a letter from a doctor. You can add to this if you need, and 650 will send you that, and your doctor can fill it out and sign it. You answer, the other questions in here, I'll just pretend I've filled all these out, but it's everything you need to answer for your situation. And then when I'm done at the end here, I'll choose that I want to indicate my preferred pronouns. I'll choose my preferred pronouns, and then I click generate, and it will email me a document like this. I open the document. It's a Word file. So if I need to make changes, or I want to make changes, or I'm working with an attorney and I want them to review it and maybe make any changes that they want to make, they can do that. And then I have all of my documents all filled out with everything that I need, plus really thorough instructions. So up here, if I click on this, it'll take me to this guide, which is instructions on the entire process, all the way from what you need to do to request and apply for a fee waiver, down to the specific steps to amend your birth certificate. And hide amendments so that it looks the way that somebody who's changing their gender marker wants their new birth certificate to look. It's easy enough and simple enough and intuitive enough that anybody can use it. So there are tools like Hello Landlord and identity are meant for anybody to use, with or without an attorney. This is one that can be used by attorneys. Attorneys do use it because it lets them automate the tedious stuff, the paperwork, so that they can focus on big picture stuff, the strategic lawyer stuff, like preparing a client for a hearing. We're working on an event right now called Gender Marker Day. And that's where Utahns can get a court order to change their gender marker in a single day. We think it's the first of its kind in the nation, which is really neat. That's something, by the way, that takes months normally and costs hundreds of dollars. And part of what makes it possible is that a few volunteer attorneys can help dozens of people because 650 automates all the paperwork for them. That's helping the helpers. Last, I want to talk about forms. Or actually, really quick, so we can't go into all of our Help the Helpers tools. One that we love, one I'm really proud of, is our immigration tools for Ukrainians. We're also working on a restraining order tool in the state of Illinois with some fantastic organizations in the state of Illinois. If you want to be involved, if you want to be one of those helpers we help, please get in touch with me. I'll have my contact information at the end of the slide deck. Now we're going to talk about forms, which are just so exciting and thrilling, I know, but it's very important because, like I mentioned earlier, for most people in most situations, forms are either a big way or often the main way that they interact with the law. You think of all the different things that, can be considered a form. And as a bit of an object lesson on why this is important, 650 built a free tool called Free Will 650. And it helps, it creates a simple will, a power of attorney, and advanced care directive for Utahns. When we started the project, we thought, hey, this might work in dozens of states, and we hoped that it would, but it doesn't because of forms. So here's the thing: 29 states have the same law, or they enacted the same law for power of attorney. It's called the Power of Attorney Act of 2006. You can see all these states in blue enacted the Power of Attorney Act of 2006. And Utah is one of those states. And we automated power of attorney for Utah. But people in those states can't use 650 to create a free power of attorney because the paperwork is completely different in every single one of those states. We looked at all of them. Here's just a random, here's the one we did, which is Utah. There's Texas and Connecticut. They're totally different forms. So same law, completely different forms. And the document, that's where the rubber meets the road. That's the thing that gets notarized. That's the thing that you hold. And for most people, forms are the main way they interact with the law. It should be simple. It should be intuitive. It can't be perfectly uniform, of course, because the law isn't perfectly uniform. Life isn't perfectly uniform. But forms should be as simple and as uniform as we can make them. And right now they aren't. So 650, we're announcing we're starting now and probably going to, we want to have in earnest going by next year, the Simple Forms Initiative, which will be a partnership of legal, tech, and nonprofits working to improve access to justice through better forms. Forms that are simple, written in plain English with support for as many languages as possible, available on court websites and built for accessibility. Forms that are uniform, when the law is the same, the forms should be the same. When the law is different, the forms should only differ where the law differs. So in the Power of Attorney Act of 2006, that was 17 years ago. Those 29 states have made changes to their own power of attorney law, little changes here and there. So the forms should just have little changes here and there, not be completely 100% different forms. And last, we believe that forms should be free, meaning like the application fees to use forms should be waived because we believe that courts and government agencies should be funded by taxpayers. The law belongs to all of us. We all benefit from the law. It should be funded by all of us. When we fund agencies and courts with fees, it creates a barrier that doesn't apply equally to all people because, $400 to one person is something that can change their life. $400 to another person is almost nothing. That's in a nutshell, 650's approach to pro bono. We call it pro bono at scale. Please visit 650.com/pro bono if you want to get in touch, if you want more information, if you want to know more about some of our roadmap plans. and I'm also going to have my contact information here to keep the conversation going. I also had to put up this great quote from Dino Himonas. Dino's an access to justice, hero. We think he's fantastic. He runs the Salt Lake office of Wilson Sonsini, where I work. But here is our contact information. And now I'll drop that in the chat and stop sharing my screen so we can open it up for questions and discussion. I'll note I'm not an attorney, but if you ask a legal question, I'm happy to run it by our legal team, the folks at Wilson as well.
Cool. Well, thank you so much, Ransom. Thank you for sharing your story.
Absolutely.
And sharing about the 650 story. I did not know. I knew about 650. I thought that was a really progressive step for a law firm to create a tech subsidiary a few years ago, and others have followed suit since then. But to also have a branch within 650 that is a pro bono branch, I think, and have somebody like you in charge of that, I think is really I think it's a leap forward, for the legal profession. Think about legal tech, a law firm creating a subsidiary, and part of what the subsidiary does is pro bono, because there's a pro bono function for legal tech and for a law firm to kind of advance that. A minute questions. Anyone in the group has any questions or? Okay, Will has a question.
Okay, well. Oh, hey, that's convenient.
I'm a computable contracts developer at CodeX. I'm very interested in your code. What do you use for document automation? You have, I assume, some like custom in-house software.
Yeah, we built a proprietary document automation engine that we've adapted over the years to meet our new needs. We're totally overhauling it right now so that we can be a little bit more nimble. We can make more intuitive interfaces for the end user. And we can also kind of scale things up with more agility.
Cool. Do you have any plans to open source any of that?
Not on the immediate roadmap, but it's something we've looked at. In the past, we looked at, can we productize the authoring tool itself? Because the authoring tool is pretty cool. And, it's something that we think can go head to head with, any document automation on the market. For now, at the time, the decision was made, no, our value to the market is content and expertise that's, delivered by technology and our own in-house home-cooked document automation. But we may revisit that if it's something that, right now, as somebody who does a lot of document authoring, I don't think it's ready to productize. But if the things we're working on coming up are really exciting, and that could be something down the line. We do work with organizations on projects together. So the thing we're doing in Illinois is with Chapman and Cutler and Legal Aid Chicago, two phenomenal organizations in Illinois. And we do a little bit of sort of co-building with them, but even with close partners, we don't currently open up the document automation. Really good question.
Hey, thanks. It looks awesome.
Yeah.
Oh, thanks so much.
All right. So are there any other questions from folks on the Zoom? Tobias, you have your hand up.
Yeah, just a quick comment that there's a relationship here. So part of why you would want to create a machine readable representation of a policy, especially the type that use these Flint standards and can be knowledge graphs, is for that kind of application, right? So if it's open, then that's something that you could leverage as knowledge services. Those kinds of things that say, what is your context? Based off your context, which rules apply to you, and so on. And the vision would be that that could all be open source and open standards, so that product builders like yourself, that maybe whether it's forms or some kind of other application, can just leverage that sort of thing instead of writing your own decision logic in your own software code to tease out what a policy says in its deontic logic in a machine readable form.
Oh, I absolutely agree. I think that's, personally, I would love to see 650 as more of a platform. We've talked about a long-term goal of making productizing something that can be used by anybody who wants to, use or create a new pro bono or, a new document that pro bono attorneys can use, and then figure out the licensing so it's only used for that and not, for profit. But then it also helps us be part of the larger conversation about setting, rules and standards. I would love, I wrote down your email address, Tobias, because I'd love to get in touch and hear more of your thoughts on, more of what you're describing.
All right, Ransom. Well, thank you so much. We're like 3 minutes over time. So let's close it. Those were two great presentations. I see others in the chat. Also, really appreciating your both of your presentations. Thank you so much. And yeah, please keep us posted, and really appreciate all the great work you're doing to advance the state of the art in legal tech. Yeah, so thank you all in the group for tuning in again this week. Susan, are we meeting next week again, or when's our next session?
So I just dropped into the chat. We're on pause next week, but we're back with Meet CodeX on October 11th. So that's virtual or on ground for people who can join us on campus. So look for more information in your inbox if you're signed up for our mailing list, or click the link on the chat to register, and hopefully we'll see you all there.
Okay, super. Thank you all, and a quick round of applause for the presenters again, and see you all on October 11th then. All right, thank you again.
Bye, everybody. Thank you.
Thank you. Bye-bye.